Hello, I'm Vincent J. Russo of the Russo Law Group and co-host and creator of Family Comes First on CFN. Today we will continue with our series on long-term care, which is being presented in 3 parts. At age 65, your chances are 50-50 that you will develop a disability serious enough to require long-term care services. And about 1 in 6, 17%, will end up spending at least $100,000 out of pocket for such services. And this could be much more in New York. In Part 1, we covered what is long-term care and how do I pay for it. We learned that if you need assistance with activities of daily living, ADLs, Medicare and Medicare supplemental insurance will not cover you. There are only 3 options: privately pay until you are impoverished, purchase long-term care insurance, or qualify for Medicaid. Today, we will discuss the important role of the Medicaid program. Medicaid is the only government program that will pay for long-term care. The program varies state by state as to the levels of coverage and the financial eligibility rules. For our discussion, I will be addressing Medicaid under New York law. Now for an overview of the Medicaid eligibility rules. Seniors age 65 or older and people with disabilities who meet the financial eligibility requirements may qualify for Medicaid. The Medicaid applicant is allowed to have a small amount of non-exempt assets, approximately $15,000, and generally your home is exempt. If you gift assets within a certain period of time prior to applying for Medicaid, then Medicaid can assess a penalty. The penalty is that you will not be covered under the Medicaid program for a certain number of months, depending on how much you gave away. It is also important to note that there are exceptions to the transfer penalty rules for outright gifts and for your primary residence. For example, transfers to certain individuals, such as a spouse or a child with a disability, are not subject to a penalty. There are also special rules for married couples that allow the well spouse to keep a certain level of assets and income. And there is the doctrine of spousal refusal, which can allow the well spouse to keep even a greater amount. To apply these rules to your situation, you need to know that there are basically 2 programs for Medicaid coverage: care at home and care in a nursing home. There is also coverage for a limited number of individuals residing in assisted living. For community-based home care, once you qualify, you can receive at home the necessary long-term care services that you need. For now, the current rules do not have a transfer penalty if a Medicaid application is filed before April 1st of 2021. This date may be extended by New York State. Once the new rules are implemented, then transfers within 30 months of the Medicaid application will be subject to a transfer penalty. Once you are approved for Medicaid and arrange for the services, you are then subject to a monthly income budget, and further planning would be required to protect your income in excess of the budgeted amount. As to nursing home care, there is a 5-year look-back period for transfers, which then may be subject to a penalty. So as you can tell, the Medicaid rules are complicated and, quite frankly, irrational. The stakes are very high. Clearly, this is not the way we should be taking care of our seniors and people with disabilities. Nonetheless, one needs to understand the Medicaid eligibility rules and then plan for Medicaid, just in case you need the care. No senior should lose their lifelong savings or their home because they have the wrong disease and require long-term care and not acute care. In Part 3 of our series on long-term care, I will discuss with you how to qualify for Medicaid. For more information on long-term care, you can download for free our Medicare and Medicaid guide from our law firm website at vjrussolaw.com. I look forward to Part 3 of our series on long-term care. Meanwhile, be well and be safe. This is Vincent J. Russo in the Legal Know.